So I was looking at paragraph 34 of the Upper Tribunal decision on page 73 of the core bundle, where the Upper Tribunal is discussing Edwards and Bairstow. So they note that the appellant had no permission to make an Edwards and Bairstow appeal, but they also decide that there's no such error of law by the FTC in any event. So at 36, they state that the factors mentioned there are not irrelevant, and that the appellants are seeking to do what the court in Edwards and Bairstow and Georgia prohibit. Those factors, which are listed in para 33, are the same factors which are listed in 3.15 of the appeal skeleton to this court. So the Upper Tribunal lists the failure of the appellants to take pensions advice, the similarity of the conclusions reached by the two companies, the calculation of the provisions by reference to a percentage of profits, the fact that the arrangements were brought to the notice of the appellants as a tax saving scheme, and the lack of commerciality in the arrangements. And then there's a further factor listed in 3.15 of the appeal skeleton. There's no evidence that Synergis and FLB had any special expertise. So the appeal skeleton asks the court to find that none of these points point to an all-pervading purpose of avoiding corporation tax. That's at 3.16, and that they conflate reason with purpose. That's at 3.17, the skeleton. So the appeal isn't couched in Edwards and Bairstow terms, but it's asking the Court of Appeal to decide that there's an Edwards and Bairstow error in applying the incorrect test, being taking into account irrelevant factors. So if I can pick up then at paragraph 23 of my skeleton, which responds to the appellant's grounds of appeal.
Just before you do that, Lord Justice Singh, I think it is, in the Marlborough case, does have a bit of a debate about the extent to which challenges to wholly and exclusively involve Edwards and Bairstow or legal challenges, noting that it's been put slightly differently by Lord Justice Millett and I think Lady Justice Rose as she was at the time. Do you want to make any observation about that?
I can do, my lady, but I would need a particular paragraph that you're referring to, if that's possible.
Well, it's just because I think you're taking it as read, really, that this is all Edwards and Bairstow and it's a finding of fact. Whereas, if you go to the authorities bundle, tab 52, make sure I'm finding it. Paragraph 112 introduces the point, page 534, comparing what Lady Justice Rose says in Investec with what Lord Justice Millett says in Vodafone. Lord Justice Singh finds it unnecessary to resolve that, and at 120 he applies the principles in Vodafone, which really focus on it being a finding of fact. But if you go back and see the way that Lady Justice Rose expresses it, at 116, you can see the tension.
I mean, it's perhaps not directly relevant to this appeal. I mean, my learned friend does couch his appeal in terms of errors of law absent Edwards and Bairstow, and I'll be addressing all of those points. If my lady does feel at the end of that it is still relevant, then can we come back to that?
That's fine. I think we just need to be a little bit careful about what is factual finding and is or is not susceptible to an adverse challenge, and the way the case is put about against you, which I think is largely about application of the principles, which could suggest an error of law, not in the Edwards and Bairstow sense of you couldn't possibly have made that finding of fact,
Yes.
but in a
Well, I
legal
agree
error
with that.
sense.
Yes, it's couched in terms of errors of principle and not Edwards and Bairstow.
I mean, one might suppose, this is possibly getting it off at a tangent, but one might suppose there are two distinct aspects. One is where a tribunal makes a finding as to what was in the mind of somebody. That surely is a question of fact. And the other, once you've worked out what the facts are, do those facts in law put you on one side of the line or the other, which would be a question of law.
Yes, I would agree with that.
I mean, a primary example is Malieu and Drummond itself, isn't
Yes.
it? Because the House of Lords had no difficulty in determining effectively what they treated as a legal question.
Yes. Yes, indeed. And her intentions or conscious motives were held not to be relevant to the object that they found. Yes, it's all very tricky. I don't blame my learned friend entirely. Responding to the points in the skeleton, so his ground one is that the Upper Tribunal and the FTT misapplied the decision in Scots Atlantic.
Sorry, where are you going to your skeleton now?
I'm making the points in my skeleton.
Right, would you mind just giving me the reference again?
So I'm at paragraph 23 of my skeleton.
Page 52.
Thank you.
So my learned friend is asking you to decide that the Upper Tribunal and the FTT misapplied the decision in Scots Atlantic by failing to find an all-pervading purpose of avoiding corporation tax. So that's his skeleton at 3.7, 3.14, 3.16. We say that's misconceived. In order for Section 54 to apply, it's sufficient to find that the expenses were incurred for a non-trade purpose, including a tax avoidance purpose. It's not necessary to find that the tax avoidance purpose was an all-pervading purpose, and it will be wrong in law to fact match with another case, and neither tribunal in this case did so. So in Scots Atlantic, I think it's worth going to Scots Atlantic. So the approach of the Upper Tribunal was that at 50 to 55 it identified the principles that we've been to, distinguishing between the taxpayer's purpose in incurring the expense and the taxpayer's choice in how it achieves a trade purpose, noting that the mere fact that a choice is influenced or dictated by the tax consequences doesn't necessarily mean that the choice involves a duality of purpose. So at 58, I'm at page 335 of the bundle. It noted that the determination of a person's purpose is one of fact, but the appellant's argument was that the FTT erred in law in treating an incidental result as a purpose. So that's at paragraph 58. And then 59 to 70, it considers the FTT's decision, including its finding that there's an all-pervading object of achieving a deduction. And then from the end of para 67, they say, actually there was a rather long passage, if I can just ask you to read that. So from the end of para 67 to the end of para 70.
We'll do that. Yes.
And then at 71, it concluded that the FTT's decision contained a finding that one of the purposes of the expenditure, in contrast with the purpose of the chosen method of effecting the expenditure, was to obtain a tax deduction. So the Upper Tribunal did not decide that a tax purpose must be all-pervading in order to preclude a deduction. And the Upper Tribunal in the present case correctly applied the case law principles applied in Scots Atlantic to the facts of this case.
Well, the all-pervading finding was just a finding by the FTT. Well, it certainly was a finding by the FTT, but not.
It was a finding.
That doesn't mean it's a necessary part of the test.
No, quite. So the appellant's assertions as to the facts of their cases, so for example, the intention of the companies was to create pension rights for employees, and the object achieved was the creation of pension rights, and there's no finding that the amounts were excessive. They're contrary to the factual findings of the FTT as to what the aims of the appellants were, including in particular those I've taken the court to. The findings of the FTT are detailed and careful. They are supported by substantial evidence, summarised by the Upper Tribunal at 15 to 18, and that's page 68 of the bundle. They found the witnesses not to be credible. We've taken the court to those passages. And that's picked up by the Upper Tribunal at paragraph 17 on page 69. So in making those findings, the FTT didn't confuse purpose with natural consequence, as the appellants contend. They found that the first thing that happened in relation to the herbs was a meeting with Charterhouse to discuss the tax treatment of the herbs, and that there was no separate discussions on pension remuneration, rejecting the witness evidence on that. Finding that there was no advice taken on pension remuneration based on the scope of the engagement letters with Charterhouse, Synergis and FLB. So that and all the other evidence relied on point away from the directors having a purpose or object of paying pensions. And they support the finding that the payment of pensions was an incidental aim of the herbs, or an incidental effect. The FTT didn't take into account irrelevant considerations. So none of those matters are irrelevant. So the appellant's ground 2 is that the decision of the Upper Tribunal in Scots Atlantic is wrong, and that the tribunals below erred in law in applying it. So the reasons their skeleton gives is at 4.3 of their skeleton. So they say the decision of the Upper Tribunal in Scots Atlantic misapplies the words of Lord Cross. That's the example that my learned friend has taken to such an extent that it comes to the opposite conclusion of what Lord Cross laid down in Kilmorey. But it's Ransom and Higgs which is the starting point for the line of authority, so Scots Atlantic has gone wrong at the first turn. So I've been to the decision in Scots Atlantic, which is not relied upon by the Upper Tribunal. The principles of the House of Lords and Court of Appeal cases cited by the Upper Tribunal are relied on. Those are correct. So even if what's said at 4.3 of the appellant's skeleton is correct, it wouldn't get them anywhere. They now rely on the decision of the Court of Appeal in Hoey, but as we've already seen at para 170, Lord Justice Henderson summarised exactly the same principles by reference to the same case law, and held that an other purpose, i.e. a non-trade purpose, can include obtaining a tax advantage. That's Hoey at para 171. And then it can be seen from para 188 of Hoey that it was an Edwards and Bairstow appeal. It doesn't lay down any new principles. And that's page 454 of the bundle if you want to go to it. At para 192 to 194 of that decision, that's page 455 of the bundle, the court is considering the question whether a person is trading, not the section 54 question. So the point that's being made at 194 of Hoey, this is on page 456, relates to the question whether or not a person is carrying on a trade, not whether the expenditure is only exclusively for the purposes of the trade. So the point is that fiscal motive doesn't denature a trade. I believe my lady was involved in the Ingenious case. We're very familiar with those cases. And then paras 197 to 8 of the Court of Appeal decision decides that in that case, payments by Mr. Hoey's employer to the EBTs, which were held there to have formed part of Mr. Hoey's remuneration, had as their object and purpose payment to Mr. Hoey for his services. So the court doesn't set out any new principles, it applies the well-established ones to the findings of the FTT in that case. And then at 199, page 457, they make their conclusions on Edwards and Bairstow that the FTT was entitled to reach the conclusion that it did on the facts. So that case doesn't assist the appellants at all. In terms of the Lord Cross example that we've been to already, of a taxpayer who incurs expenditure of £10 on the purchase of trading stock, and because the taxpayer wishes to help his son-in-law, he chooses to buy the stock from him rather than from an unconnected third party. Lord Cross correctly stated that what's now section 54 does not preclude a deduction for the expenditure merely because of that non-trade choice. But that's the same point as the one made by the Upper Tribunal in Scots Atlantic at 55. Namely, a deduction is not denied merely because the taxpayer chooses, for non-trade reasons, a particular method of achieving his trade purpose. So there's no inconsistency between that example and the reasoning and decision in Scots Atlantic. So neither the Upper Tribunal nor the FTT in this case disagreed with that, nor did they overlook it. They both made exactly the same point, that a distinction must be drawn between a non-trade purpose on the one hand and a non-trade choice of method of achieving a trade purpose on the other. So that's in the Upper Tribunal decision at paragraph 49 on page 76 of the bundle. So the taxpayer is entitled to choose a particular means of achieving a trade purpose over another on the grounds that it's tax efficient. But in order for the appellants to be able to draw an analogy between that purpose and their own purposes, they would at least have had to have made a decision to remunerate their directors by way of provision of or further provision of pensions, and considered how best to achieve that purpose, or to have chosen between at least two options. Not only was there no evidence to support that they had a purpose of paying pensions, so no minutes of a separate board meeting at which pension remuneration was considered, there was no advice taken on pensions, but as I've explained, the evidence before the FTT and the facts found by the FTT points away from that purpose. So the herbs were presented to the appellants and considered by them as a means of achieving a corporation tax deduction. without paying the amount of that deduction. In Kilmorey itself, the House of Lords decided that the Special Commissioners were correct to decide that the tax avoidance purpose of the payment meant that the expense was disallowed because it wasn't wholly and exclusively for the purposes of the trade. So the Special Commissioners found that facilitating the tax avoidance scheme in that case was a purpose and not merely a secondary consequence. That's page 565 of the STC report in the bundle. So the bundle page is 196. So next,
Yeah, you should be able to get the Special Commissioner's decision in much more detail from the tax cases report that we could now go on.
yes, but I don't have the reference. I'm sorry.
Okay, so where are you taking us to? 196.
196 of the bundle.
Oh, we're looking at Lord Cross's judgment here.
Yes, so we're looking at next to F. I have no doubt that conclusion is right. This is in relation to the Special Commissioner's decision.
And the they said is quoting from whom? Sorry.
This is about the Special Commissioner's decision. So 565. Oh my gosh.
Yes.
But that's why I asked what the 19240 was, and I was told it was part of the excess.
Sorry, my lady, I didn't hear that.
Their conclusion relates to the £19,240,
Yes.
which I was told earlier was part of the excess.
Yes, but there was a point before the court. There was a point that wasn't before the court in relation to an apportionment. But they weren't deciding the apportionment point. They were just looking at the amount that was disallowed, as far as I understood it. My learned friend appears to be relying on that for a different point than is in his skeleton, but I'm answering the point that's in his skeleton, not the apportionment point.
So I think you're saying simply that the tax avoidance motive in that case did justify the denial of deduction.
Yes. So the appellants made various assertions as to the fact that there's no finding by the FTT that the relevant pension provisions were excessive.
Just for what it's worth, if you go to the tax cases report, you'll find the passage quoted by Lord Cross at page 21 in the Special Commissioner's decision. So if you have page 21 in the numbered paragraph 3, which contains 2 paragraphs, towards the end of the first paragraph you get, in our view, the latter object.
Yeah.
And I haven't looked at it long enough to understand exactly how the £19,240 fitted in.
No, I'm afraid I don't know the answer to that. I'm sorry. The apportionment question doesn't concern us for this one. The complaint by my learned friend that there's no finding that these pension provisions are excessive misses the fact that the size of the provisions in the accounts were determined by reference to the profits that they were seeking to shelter. So it was 80 or 100% of the profits. There was no concern whatsoever for the amount of the pensions that would be paid as a result of that provision.
I mean, I suppose it doesn't automatically follow that it was excessive. It may not have been calculated by reference to what would be appropriate, but it doesn't automatically follow that it wasn't appropriate.
No, but I mean, the directors didn't consider it at all. They had no regard for it. They didn't consider it themselves, and they didn't take any advice in relation to it. So it wasn't that the FTT overlooked that. They just didn't have any evidence to go on.
Well, it's more that they rejected
They rejected
the evidence in the witness statements about thinking about an appropriate level of remuneration. I forget the wording. So that evidence doesn't get accepted and it leaves a bit of a void.
Yes, but that's not a reason to send it back to the FTT and have new witnesses. If I can just briefly make some points in relation to Marlborough. So we submitted a supplemental skeleton with the permission of the court, responding to appointing the appeal skeleton because the appeal skeleton wasn't copied to HMRC in time. If I can adopt that as my submissions and just briefly make 2 points. First, that the court refers at paras 101 to 106 to the decision in Scots Atlantic. This is page 532 of the bundle. And refers to the principles from the House of Lords and Court of Appeal authorities, Mallory of Drummond, Vodafone, McKinley, after citing Militel J and Vodafone. And the court states at para 120 on 536, for my part, I'm content to apply the principles as set out by Militel J and Vodafone. Even on that basis, I would hold that the Upper Tribunal in the present case was correct to conclude that the purpose in this case was not for the purposes of NDPL's trade, but rather for the benefit of Dr. Thomas. It was a tax avoidance purpose. And the subsequent paragraphs expand on that. And secondly, that it's another example of a case in which expenditure incurred for the benefit of a company's employees was properly held to be not deductible on the ground that it had a separate tax avoidance purpose. Just 2 final points in response to my learned friend's oral submission. So he's made much of the fact that there was an expectation that pensions would be payable, but that is consistent with it being an incidental effect. It doesn't elevate it into an object. And his point that if there's reasonable pension remuneration, then it's allowable. So I've made the points in relation to the evidence and factual findings on that. But again, something being reasonable doesn't make it an aim or object. So neither of those points come close to applying the relevant tests. HMRC's alternative contention is that the appeal should be dismissed on the ground that the expenditure is prohibited by sections 1290 to 1291. If I can ask you to go to those, they're at page 82 of the bundle. So 1290 provides employee benefit contributions. 1. This section applies if in calculating for corporation tax purposes the profits of a company, the employer, of a period of account, a deduction would otherwise be allowable for the period in respect of employee benefit contributions made or to be made. And then 2, no deduction is allowed for contributions for the period except in so far as. And then it's not in dispute that those conditions aren't met, so that if one applies, then the deductions are disallowed. but they are then allowed in a subsequent period under subsection 3. So section 1291 provides the circumstances in which an employee benefit contribution is made as a result of an act or omission for the purposes of 1290. So that provides an employee benefit contribution is made if, as a result of any act or omission, A, property is held or may be used. So those are alternatives under an employee benefit scheme. And then B is not relevant. 2, for this purpose, employee benefit scheme means a trust scheme or other arrangement for the benefit of persons who are or include present or former employees of the employer, etc. So HMRC contend, in summary, that the ERBS is a scheme or arrangement for the benefit of employees and former employees, and that under the ERBS, property of the appellants will, and certainly may be, used to make payments to the key individuals. Indeed, it was used to make payments to the individuals. Or in the alternative, property is held, being the rights held by the individuals, the key employees, under the agreements. So that means there is an employee benefit contribution made under section 1291. In turn, that means section 1290 is met, in that a deduction would otherwise be allowable for the period in respect of employee benefit contributions made. And obviously it has to be assumed for this purpose that the deduction is not denied under section 54. So the purpose of section 1290 is to ensure that when an employer incurs an expense in connection with the future provision of a benefit to an employee, the employer doesn't obtain a deduction for that expense unless and until the benefit is actually provided to the employee. So the timing of the deduction for the employer is aligned with the timing of the taxation of the benefit. So we've seen that the appellants entered into the ERBS agreements, whereby they made binding promises to their employees to provide them with pensions in the future without providing any upfront funding. HMRC contend that the future pension payments are the benefit, and they're the only benefit related to the deduction claimed, so that the ERBS falls squarely within the purpose of section 1290, meaning it should only be allowed if and insofar as the benefits are paid. That purpose is clear from the statute, but it's also expressed in the explanatory notes to the Finance Bill 2004, that ERBS were intended to have this symmetry.
Before we go there, I should point out that there is quite a lot of case law commentary on whether it is appropriate to go to legislative antecedents to legislation rewritten under the tax law rewrite project.
Yes, my lady.
Both Supreme Court and this court.
I'm grateful to you, my lady, for making that point. The points that my learned friend made today are entirely new to me. There are no pleadings.
No, I appreciate that, and there is a point that you will need to answer about section 246, which, as I now understand it, is still on the statute book. But I'm just making a point about the provisions on which you rely. You're relying in interpreting section 1290 on provisions relating to earlier legislation which have been superseded by that.
That is correct, my lady. I am.
So, I mean, I won't. The cases include Derry in the Supreme Court, the Alexander Beer case in this court earlier this year. There's a potential exception for previous case law, but not antecedent legislation, because the theory is that the point of the tax law rewrite project is to rewrite everything in an accessible way so that you don't need to go back to earlier statutes.
Is My Lady minded to preclude HMRC's reliance on the 2004?
I'm very happy for you to make your submissions, but I wanted you to be aware that that was on my mind.
Could I perhaps ask permission to submit something in writing on that?
Well, HMRC should have been prepared for this because the point has come up on successive occasions. So I'm not immediately sure that would be appropriate.
Fine, My Lady. We don't heavily rely
but
on these.
please, do make your points. And I thought it would be unfair if I didn't raise the issue now.
Yes.
And there is a chink in what I say when it comes to section 246, because we've got the oddity that part of the original statutory scheme is still on the statute.
It is. I'll make submissions in relation to section 246. I mean, I can make them now,
Yeah.
if you like.
Well, you take it in your preferred course.
Well, I wasn't prepared to make submissions on 246 because, as I say, it's a brand new point. But the point is simply that all that it shows is there's no deduction for EFIRBs or employer financed retirement benefit schemes. We agree this isn't an EFIRB as defined in that section. We don't agree there's that there's a special privilege, as my learned friend put it, for schemes which only confer pension income. He's ignoring, he doesn't engage with sections 1290. I mean, it doesn't help him to say that it's not an EFIRB within section 246. It doesn't address 1290 at all.
Well, the potential relevance is that, as I understand it, you both rely on section 1290 as having derived from, I think, section 245.
Well, no.
And if it is relevant to look back to the Finance Act 2004, you've got two separate provisions, one dealing with contributions and one dealing with what you call EFAs.
Yes, I mean, there's a myriad of changes to the legislation which I'm not referring to.
Indeed, which is why I made the point I did 5 minutes ago.
But we say all of those changes to section 1290 make it abundantly clear. So it's abundantly clear in its present form that it's supposed to catch ERBs. So I don't need to rely on the explanatory notes. But I mean, it's expressly stated in the explanatory notes, which is why we have referred to them.
Can we then go to them for whatever they may be worth? So we're dealing with the explanatory notes for the 2004 Act, which are at 18 and 19, are they, in the authorities bundle?
I believe they're at page 63.
Yes, yes, tabs 18 and 19.
Thank you, my lord.
And at tab 18, page 62, it says clause 232. I assume clause 232 became section 245.
Yes, it did.
And I assume that the explanatory notes for clause 233 became section 246.
We think so.
And in that, if you just start there, the summary at page 64 relating to what became section 246 says this clause relates to expenses for an employer other than contributions in providing benefits.
Well, the passage that I was putting to the court was the last sentence of paragraph 11, which is on page 63. So unapproved retirement benefit schemes will no longer be necessary unless the employer wishes to provide benefits of the sort that would not be permitted under the simplified regime. So this is a reference to the simplified pension regime that was enacted in Finance Act 2004. And 12, if employers and employees enter into such arrangements under the new regime, it will be treated as an employer-financed retirement benefit scheme. This will receive similar treatment to any other scheme that provides taxable benefits to employees.
But that, I'm not sure how that helps you, because it doesn't tell you what they mean by an unapproved retirement benefit scheme, which could have been a funded one, not necessarily an unfunded one.
But the point, so my learned friend is relying on 246, which relates to EFERBs. And
Well,
says that this
it
isn't an
relates, on the face of it, when you first open it, it relates to precisely this situation, which is an unfunded arrangement for which provision is made in the account.
The opening of 246, you mean?
Yes.
Yes. But then it says there's an exclusion for EFERBs, I think it is. So EFERBs are taken out of the. Is that right? I mean,
Well, we were taken to it, but you have to go via what is now section 393A of ITEPA.
Yeah. So, I mean, my submission is that all of those sections together are supposed to comprehensively disallow deductions for all types of pension schemes. Whether it's an ERBS, an EFERB, a registered pension scheme, none of them are supposed to get a deduction until there's a taxable benefit.
And I see that in a general sense, but looking just at the explanatory notes, it rather looks as though the revenue envisaged or Parliament envisaged a two-way split. You either had a contribution-based scheme, or if you didn't, you looked for clause 233, section 246.
But the regime was simplified for registered pension schemes, which is what 1290. 1290 is aimed at all pension schemes, and then there's a remainder provision for EFERBs. But this is saying that ERBs are supposed to get the same treatment as EFERBs. So together, they were all supposed to have their deductions denied. So 12 is saying that ERBs is supposed to get the same treatment as EFERBs. Then EFERBs is saying you can only get a deduction when taxable income is received. So the next point relates to the current wording of 1290, or the relevant wording of 1290 at the time that these deductions were taken, which is that it no longer includes a requirement for the employer to pay money or transfer an asset to another person. So we've now just got any act or omission. So I say it's clear from that that it's intended to apply to unfunded, unapproved retirement benefit schemes, which inherently don't involve a payment of money or a transfer of assets. So from the employee's point of view, the promise to pay pension payments doesn't count as earnings for income tax purposes. They would only be taxable on pension payments they receive. So the Upper Tribunal decision deals with this. They first say that they don't have to deal with it. And this is starting at paragraph 59 on page 78 of the bundle. But then they give a number of reasons why, in their view, section 1290 doesn't apply. So they first said, at 71 on page 80, that the ERBS was not an employee benefit scheme as defined on the ground that trust scheme or other arrangement is limited to a trust or similar arrangement. We say that's far too narrow and that it plainly is a scheme or other arrangement.
Sorry, can you give me the paragraph number again?
It's para 71 on page 80.
Thank you.
In particular, there's no requirement for there to be another person holding property. That requirement was removed. They take support from the decision in NCL in the Supreme Court. I'll come on to that in a moment. That's about the grant of options. We say options are fundamentally different in that they're not arrangements. Here we have arrangements for the provision of retirement income. So once an option is granted, there's nothing left to do. It's just an agreement or a single transaction.
Well, that's not entirely true, is it? The option still needs to be performed if it's exercised.
Yes, the employee has the right to exercise the option.
Yes, but if he does, it's still the contract created by the exercise of the option still needs to be performed, just as this contract would need to be performed.
Well, the employee doesn't have to do anything for this contract to be performed. So we have an arrangement or a pension scheme under which the employer is obliged to make pension payments in future. So in my submission, that's a conceptually very different thing to an option.
But I just make sure I've understood your submission. You say that options are not arrangements.
And well, as a matter of ordinary use of language, an option is not a scheme or arrangement. Whereas a pension scheme, as a matter of ordinary language, is a scheme or arrangement. And here we have a pension scheme. The Upper Tribunal also held that the promise to pay the pension payments in future was not property held under the scheme. We say the requirement is only that property may be used. The Upper Tribunal doesn't actually address that point. And it's clearly the case that property of the appellants may be used to make the pension payments under the ERBS. The ERBS is the scheme or arrangement. Therefore, property may be used under the scheme as a result of the act of entering into the ERBS. So that point is overlooked by the Upper Tribunal. That's para 72 on page 81. We do also submit in the alternative that as a result of those binding promises, the directors or the key individuals hold contractual rights under the ERBS, which is property. So that property is held as well. And thirdly, sections 1290 to 1, as you've seen from the language, don't require a payment of money or transfer of an asset. They only require.
Sorry, where are we now?
So I'm going through the reasons of the Upper Tribunal. But
Yes, sorry, where, in that case, where are you in the Upper Tribunal?
So we're on page 81, I believe.
And which paragraph are you in? Yes, yeah. Yes, I see. So here the thesis is that the contractual rights may be held or used under an employee benefit scheme.
The Upper Tribunal places heavy reliance on the decision of NCL, and I say we're totally different to NCL because that was about options, and I'll come on to the Supreme Court decision in NCL in a moment. So, I mean, the point about options is that the option itself is a benefit in the hands of the employee. If I can ask you to go to the Supreme Court decision in NCL, we've got two different references. So my bundle reference for paragraph 70 is page 392, and I believe it's 1850 of the weekly law reports, if you're relying on those.
Paragraph 70.
Paragraph 70 of the Supreme Court. So once the options are granted by the companies to the employees as part of their remuneration package, their purpose is spent so far as the companies are concerned. The option is not a potential emolument. And then the option is an actual emolument, and the options are not, once granted, held by the employees, i.e. the later receipt of shares when the option is exercised is not a benefit. And so the benefit is the option itself. It's not relevant in the present case because the binding promise isn't itself a benefit in the hands of the employees. But the receipt of income by way of the pension payments is a benefit.
And just tell me, why isn't the binding promise a benefit on this thesis?
In NCL.
Well, no, you say it's not relevant in this case because the binding promise isn't a benefit. Well, why wouldn't the binding promise be a benefit?
That's based on Abbott and Philbin. I don't think there's anything controversial about that. The promise isn't a benefit that's chargeable to income tax.
Or rather, what's based on Abbott and Philbin is the Supreme Court's decision that the provision of the option itself was
taxable
as an emolument.
Yeah.
Whereas no one's arguing that the provision of the promise in this case was. So, as I understand it, you simply distinguish NCL on that basis.
Yes. That only speaks to the question whether the directors hold property, not the alternative that the appellants have property that may be used.
Yeah, that feels very artificial. that an individual with the benefit of a pension promise has property that may be used under an employee benefit scheme. It's just
No. It's the appellant's property that may be used. So the appellant is going to be making payments under the ERB's agreements.
I'm not keeping up properly. So,
But I think we're talking about your alternative argument,
Yes, sorry.
where you say it is property
Yes,
of the employee.
that is
And I
the
think
yes.
you
That's
do
what's
need to
addressed by
answer-
the Upper Tribunal, but not that property may be used. And for either of those reasons, you can come within section 1291.
so can we just take the second possibility that the benefit of the promises is property held by the promisees?
Yes,
So then you say that the benefit of those promises is held under or may be used under an employee benefit scheme.
yes. So the employee benefit scheme is the trust scheme or other arrangement, which I say is the ERBs.
So anybody who is a beneficiary of a pension scheme inevitably has property that is held or may be used under an employee benefit scheme.
Yes.
So this catches every type of pension promise, I suppose.
Yes, but of course if we were talking about an ordinary pension scheme, we wouldn't be here because the deductions are denied until there's a taxable receipt. This one is hoping to slip between the cracks, as it were.
And just talking around things a bit longer, when will section 246 apply and not section 1290?
I would
Has it got a
hesitate to
role?
give you an example because it's not
simply from the provisions we were taken through earlier, it appeared that the only reason that 246 wasn't in point here is because the payments, when finally made, will all be taxable as pension income. There won't be anything like a lump sum or something like that. That's my understanding. Otherwise, they would apply.
So just developing that, on your case as to the construction of 1290 and 1291, will 246 have any role?
I don't rely on 246.
No, you're not relying on it, but I'd like to know whether your case means that 246 is just spent.
246 is not spent.
It will have a role.
Doesn't apply in this case.
So in what circumstance would it apply and not 1290?
As I understand it, it's we don't know the answer to that. But it may lie in the changes that were made in Finance Act 2004 and the types of pension schemes that were around at the time. I don't know. So far as I understood it, my learned friend has got no answer to the argument that property of the appellants may be used. This is a point that was overlooked by the Upper Tribunal as well.
Well, I don't think we've heard the appellant's case on this.
We haven't, my lady, and it wasn't pleaded either, so I've been completely in the dark until today, and there have been some new points raised.
Yeah.
Yeah.
For either of those reasons, the appeal should be dismissed.
Thank you very much. Mr. Thornhill.
When I deal with section 1290 and its following sections first, the point of directing the court's attention this morning to the 245 and 246 sections was to show that it really was quite simple for tax purposes for a change. Either contributions have been made or they haven't. And in a case of unfunded pensions, I mean, the name almost speaks for itself. No contribution has been made. Now, of course, it could be the case technically that when Schedule 24 of the Finance Act 2003 was transmogrified into sections 1290 following of the Corporation Tax Act, that everything changed, but nothing really has changed at all. The basic definition of employee benefit scheme is the same. There's got to be a contribution, and there's got to be property held in the scheme. The property, of course, emanating from the contribution. My learned friend has sought, I would submit unsuccessfully, to force everything into section 1290, with the consequence, as I think my Lord Justice Newey pointed out, section 246 will be robbed of all meaning. There'll be nothing left to be covered. And that is a surprising and unexpected result. But when one looks further into the matter, the way in which property is identified by my learned friend surely won't do. I mean, to say, oh, well, somewhere amongst all the assets of the appellant companies, there will, or maybe, because it's future, some property which will be used to make the contribution. That can't have been the intention behind section 1290. You've got to be able to identify the property. You can't just say, well, it could be anything that turns up in the next 20 years when you feel like paying the pension. And as I think was pointed out in argument, if the alternative argument is, oh, well, the property is the benefit of the pension promise, well, who holds the benefit of that promise? Not some third party acting as a trustee of a scheme, just the promisee, the pensioner himself. So, with great respect, I must admit that those submissions fail. And why is it, one might ask? Why is there this temptation to put everything into section 1290? Because, as your lordships, as you've seen, the effect of section 246 in general, is to achieve exactly the same delaying effect as section 1290 now does. It's only in the exceptional case of pure pensions, which are not relevant benefits, that section 246 allows immediate deduction. Now it said, oh, well, if you look at the notes, you can see that the opposite was intended. In fact, if you look at the notes, in my respectful submission, you find absolutely nothing to support the view that all pension benefits were suffering from a restriction of deduction. Now, I need to find the correct explanatory notes. I think they are
pages 62
60 something rather.
64 for the one.
Is section 64, I take it, is dealing with 246, because that's 233, and 232 is 245. Now, if we look at page 64, we find a general statement in paragraph 4 saying subsections 3A and B provide that where a recipient is chargeable to income tax on receipt of such benefits, the employer may deduct the expenses of providing those benefits and profits in the chargeable period or accounting period as appropriate in which they are paid. Now, if we actually look at section 246, that is exactly what subsection 3 states. It says the expenses are allowed when the benefits are paid. But what, of course, is missed out is that this only applies in the case of an employer-financed retirement benefit scheme. Paragraph 5 of the notes reminds us of that. And when you look up the definition of employer-financed retirement benefit scheme, we see it does not include a case of pure pensions. So
I was sorry, just for clarity of understanding, by pure pensions, you mean amounts that are fully taxable?
yes, yes,
Under,
yes.
I think it's part 9
It's
of it.
my fault. I've shortened it down. But as soon as you read that definition and you look it up, you can see that the remarks in 4 are only appropriate to cases covered by 3A and 3B, and those are not cases which are not employer finance retirement benefit schemes. So the notes don't help at all. Far from giving any help to my learned friend, it seems to me, with the greatest respect, they set out the law entirely clearly.
Can I just circle back one moment? You were comparing 245 and 1290, I think. I mean, one change is in the definition of employee benefit contribution, as I understand it. You can tell me I'm wrong. So under Schedule 20...
Can I just stop, Your Lordship?
Yes.
Are we in section 246? If we're in
No,
section
you're not. You're quite right. We're in Schedule
if we're
24.
in 246, we're in employer finance retirement benefit schemes. You only have to look at employee benefit scheme if you're in section 1290.
Sorry, I've confused myself now.
Well, I'm afraid I'm probably confusing a law.
No. I
Let's
think
start again.
It's my fault. So under 1290,
Yes.
we're dealing with employee benefit contributions, and employee benefit contribution is defined in 1291 by reference to property being held or may be used as a result of an act or omission.
Yes, indeed, yes.
And that was a new definition. As I understand
It was slightly new, but essentially it's the same.
Just
Because the original.
probably confusing myself, but if I go back to Schedule 24 of page 4,
Yes.
it is a rather different definition of employee benefit contribution.
Yes, it is true. It talks about something which in every obvious sense would be a
A
contribution.
conventional contribution, such as one might
And
expect.
unfortunately, ingenious people managed to get round direct transfers. So Parliament had to say, well, hang on a sec, there are other ways in which you can get property into a trust, and those will count as well.
And I follow that, but one might say, well, it could be that a side effect is that things that wouldn't previously have been thought to be within the scope of 1290 or might not otherwise have been brought within 1290 are brought within 1290.
Yes, it's conceivable. Yes, you can't rule it out. But on the other hand, when one actually goes to 1290, it's still talking about contributions.
Well, it's in the defined term. It doesn't use it. It's within the concept. It's within the term employee benefit contribution, but the content of the definition doesn't expressly require a contribution.
Yes, but there's still got to be property held.
That's property held or used.
Yes. And I mean, that, in my respectful submission, simply can't possibly describe the simple promise to pay.
You've made that point.
So, in conclusion, I would respectfully ask this court to reject the submissions on 1290. Coming back to the wholly and exclusively issue, it possibly would be helpful to start by looking at the grounds on which the companies were entitled to appeal. Could I ask the court to look at page 93 of the core bundle? these were the grounds of appeal put before Judge Ramshaw. 1 to 4 were cut out, but permission was granted on 5 and 6. 5 is the critical one. It's very short. There is a fine line to be drawn between having a separate tax-saving purpose and choosing a tax-efficient arrangement. The first-tier tribunal erred in finding that in entering into the unfunded pension agreements, the appellants had a separate purpose of avoiding tax. Now, the essence of the case for the companies can be distilled if we go yet again to Scots Atlantic in the Upper Tribunal. Which starts at page 321, but the passage which in my submission is of the greatest importance is paragraph 67. And that is where the tribunal used the words ordinary, intended, or realistically expected outcome. And what they're saying is that if a tax deduction is the ordinary, intended, or realistically expected outcome, that is the yardstick by reference to which a result can be ignored as a separate object. And they go on to say in paragraph 68, it seems to us that this gloss on the wholly and exclusively test is either putting into other words Lord Justice Minnett's description of a consequential and incidental benefit of the payment, or it's stating in different language the proposition to be derived from what Lord Oliver said in McKinley and Arthur Young, so that the securing of the deductions cannot but be said to be a purpose of the contributions. So the critical factor, as we see it, is as follows. If this court is with me on the construction of section 246, that is to say, if a simple pension promise gives rise on generally accepted accounting practices to a deduction, that can fairly be described in the words of paragraph 68 as the ordinary intended or realistically expected outcome. Parliament has in effect said, we will follow the accountancy rules, and those rules are free of any restriction on deduction that otherwise might be there under 245 or 246 or 1290. And if one falls within those words, ordinary intended or realistically expected outcome, the result, i.e. the tax saving, can be ignored as a separate object. Those are critical words. When one looks at the actual facts of Scots Atlantic or of the facts at Marlborough, it's perfectly obvious that the tax saving that was being aimed at was not anything to do with the trade at all. It was, how do I get all the money out without paying tax and avoiding my creditors? that sort of situation is miles away from what I might say is the Hoey situation, where you're simply paying someone a salary or wages and saying, well, the realistic expectation in that situation is I get a deduction. So going back to the ground of appeal that I read out earlier, that there's a fine line to be drawn between having a separate tax-saving purpose and choosing a tax-sufficient arrangement. The issue becomes this, in my respectful submission. It's only certain kinds of tax saving, it's difficult to be able to describe them all, which count as giving rise to a separate purpose. And in this particular case, you haven't got anything remotely like that. So it was wrong, and as wrong as a matter of law. It's not a question of Edwards and Bairstow or anything like that, nor is it anything to do with section 54(2). Simply wrong as a matter of law to pick on the particular tax deduction, which was undoubtedly being sought in this case, as a separate purpose. And in any event, there is a certain illogicality because you couldn't achieve the tax saving anyhow without incurring the liability, the very real liability, which was actually being paid. So the case has gone wrong as a fundamental matter of law. I freely admit that amongst the plethora of facts found in this case, one might say, well, it does give rise to a bit of suspicion about whether these payments were reasonable in amount. But I make 2 points. The taxpayer isn't presented with a problem in an appeal of having to prove every fact which might conceivably be relevant. One has to meet the case put against one, and the case put against the taxpayer here was purpose, tax purpose. But I freely admit that it might not follow, it certainly doesn't follow, that the pension liabilities here were reasonable in amount. Perhaps they weren't. And so the proper course, I would suggest, is to remit the matter to a fresh tribunal, basically to sort the matter out properly. One or two, I mean, that basically is our case. I mean,
Yes.
one could go on forever, but I mean, it's as simple as that.
Yes.
It's either right or it's wrong, and your lordship will say which. But one or two subsidiary matters came up, which is worth, I think, just picking out. First of all, I think it was Lord Justice Newey asking about the ransom and pigs, or Kilmorey rather, the 19,240. It's certainly my understanding that wasn't the whole price, that was the extra price that was being demanded and was held not to be deductible. The second point, since we've just turned to Scott's Atlantic, is the interesting riposte of the upper tier tribunal to Lord Cross. Lord Cross in Kilmorey. Because Lord Cross, in his example, I perhaps don't need to take the court back to it, said the starting point is that the payer of the £10 had a purpose of benefiting his son-in-law. A purpose, which of course puts one on notice. Does it give rise to a non-deductible purpose? Well, Lord Cross clearly said not. And I suggest the reason why he was right is analogous to the reason which we've just been dealing with expectations of deduction. If you pay the proper price for some goods, even if there is some ulterior objective, it fades into significance, just like the tax purpose, if it's a natural expected result. That's the proper explanation of Lord Cross's example. The way it's brushed aside by the upper tier tribunal, it's quite remarkable. Because they say, in the middle of paragraph 77, absent some particular factor, unspecified, the object of that expenditure will almost certainly be found as a matter of fact to be to obtain the goods, even though the manner of the expenditure may be to benefit the son-in-law. But Lord Cross was positing that there was a purpose of benefiting the son-in-law. So
Well,
you
could
could
it-
only rationalise.
Could it be explained as Lord Cross saying it's a purpose of choosing that method of acquiring the goods rather than acquiring them from a third party?
Well, it's not, I would have thought, the obvious explanation, because he posits that there's a purpose to begin with. I want to benefit my son-in-law. So he just happens to buy the goods from his son-in-law, and well, that's just the manner in which he acquired it. But that doesn't really fit in with the positing of a purpose. I would submit to the court that the better explanation is rather like that in paragraph 67. We remember those words, the result can be ignored as a separate object. If you're simply paying the market price for the asset, the fact that you might be benefiting someone you want to benefit can be ignored as a separate subject, because the
When you say
realistically
60,
expected outcome is if you buy the goods for their value, you get a deduction.
you said 67?
Yes, 67. Remember, I quoted those words
Of Scots Atlantic.
at the end of paragraph 67. The ordinary intended or realistically expected outcome
Okay.
are thus being adopted as the yardstick by reference to which a result can be ignored as a separate object or purpose. One doesn't. I mean, at the end of the day, it's not incumbent on this court for anyone to justify Lord Cross, but I think that's the point he was getting at.
Thank you.
Now that brings me to the end of what I can usefully say, unless I can be prodded into saying anything else which might or might not assist the court.
I don't detect any more questions, so thank you very much, Mr. Thornhill. Thank you very much, both of you. You won't be surprised to know that we're going to reserve our judgment. It will be supplied to you in the normal way for you to correct our typing in English, but not, of course, to re-argue the case. We'd be grateful if at that point you would also seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, could we please have brief written submissions, and we'd expect to deal with the points in the order that we make. Finally, although it will be very familiar to all or most of the people in court, I ought to remind you of the importance attached to the embargo. I think we've had a list of those to whom the draft judgment should go. If you think of anybody else who ought to receive it, you obviously need to come back to us. But thank you very much.
Court rising able.